Okay, good morning, everyone, and welcome to part 3 of our webinar series, Understanding the Impact of Israel's New Government at Home and Abroad, focusing today on the judicial reform and the implications for Israeli democracy. My name is Adam Odesser. I am director of the Dr. Stuart Lesson's Israel Action Center at the Jewish Community Relations Council of Greater Washington, which serves as the public affairs and community relations arm of the organized Jewish community in our nation's capital. I'd like to begin by thanking all of you who are joining us here today and those of you who have joined us throughout this webinar series from our region, from around the country, Israel, and around the world. I'd also like to take this opportunity and thank our partners throughout this webinar series, the Israel Policy Forum, the Greater Washington Forum on Israeli Arab Issues, and the Jewish Federation of Greater Washington. Today's webinar is also featured as part of a Brown Bag Lunch speaker series partnered by the JCRC of Greater Washington, the American Jewish Committee, the American Association of Jewish Lawyers and Jurists, the Jewish Federation of Greater Washington Next Gen Lawyers and Lawyers Division, and Tzedek DC. Today's webinar comes a month and a half since Israel's 37th government was sworn in back on December 29th. More importantly, it seems as if it comes at an unprecedented time. Not only have we seen current and former officials raising concerns over proposed judicial changes, but also we've heard from Israeli Nobel Prize winners, business leaders, economists, and the Israeli president himself have now warned of the impact of such changes. Israeli President Yitzhak Herzog, in a passionate speech just this week, urged the coalition and the opposition to negotiate on the proposed legislation to reach a broad consensus in order to prevent a political and societal breakdown and perhaps a constitutional crisis. To introduce our speakers for today and to moderate today's discussion, I would like to pass the screen over to JCRC board member Harvey Reiter, who is also an adjunct professor at George Washington University. Harvey, the screen is yours.
Thanks, Adam. As Adam mentioned, we're at a critical moment. Not only have hundreds of thousands of Israelis marched and spoken with their feet, but we can't disregard the expressed concerns of U.S. officials and American Jewish institutions and the impact judicial restructuring, the proposed judicial restructuring might have on Israeli democracy, on the relationship between the United States and Israel, and between Israel and the American Jewish community. To discuss these developments, we're very fortunate to have two wonderful speakers to talk to us today. We're joined by Dr. Tamar Brandes, the senior lecturer at the College of Law at Ono Academic College, and Dr. Metial Pinto, who has told me that she prefers to be called Pinto. So I'm not being rude if I'm referring to her by her last name. She is a professor both at Ono and at Zefat Academic College of Law. So a bit of housekeeping before we get started. Both of our speakers will speak for about 10 minutes, and I'll follow up with a few questions that I have. And then for the last half hour or so, we'll be taking questions from the audience. So just submit your questions in the Q&A box, and I will get to them after our speakers give their talks. I'd like to try to keep your questions short so we can get to as many of them as possible. This call is being recorded, and we'll make the recording available later. Closed captioning is also available at the bottom of your screen. There's a button you can click to enable that. So Tamar, Pinto, I thank you both for being here and sharing your time. I'm going to turn the screen over now to Pinto. And again, thank you all for being here.
Thank you, Harvey, and thank you, Adam, for inviting me to this important talk. I'll just share a very brief PowerPoint presentation just to make clear things about Israeli government and Israel judicial system. Okay, so basically, Israel is a democracy. Of course, it's a parliamentary democracy. We don't have a constitution, but we do have basic laws. What does it mean? Okay, if you want to understand it, you should go back to 1951. The State of Israel was established in 1948, and the situation in Israel was a mess, great poverty, a lot of Jewish people immigrating from all over the world, a lot of disputes about the values that the Constitution or the forthcoming Constitution should protect. Some think about values such as capitalism, some think about values such as communism, some want equality for women, some don't, some want equality for Arabs, some don't. So instead of enacting a comprehensive constitution like we see, for instance, in the US or in Canada, there was a Knesset member, his name was Izhar Harari, and he offered a compromise. And according to his compromise, instead of enacting a comprehensive constitution, the parliament, Israeli Knesset, will enact basic laws. And the basic laws will be enacted in a very gradually process. There was no deadline as to which date is the date in which you say, okay, we are done with basic laws. So in the beginning, there were basic laws that were more about the structure of government, the basic law of government, the basic law of the Knesset. And that was the idea until 1992. In 1992, a very ambitious and energetic Knesset member, who was also a professor at Tel Aviv University, Amnon Rubinstein, he pushed together with other Knesset members to enact basic laws that will first be about human rights, not about the structure of government, but rather will put human rights at the front. So the first was basic law, human dignity and liberty. The second was basic law, freedom of vocation. That's the situation. Now, both of these basic laws gave the authority to the Supreme Court of Israel, which is also Israel High Court of Justice. They gave the Supreme Court the authority to strike down laws that violate human rights, which are entrenched in these two basic laws. So since 1992, the Supreme Court has this authority, which was, as I said, was given to her by the parliament, by the Knesset. And since then, we can say that judicial review in Israel is very disputed. It's very disputed, and I think that it's not rightly so, because since 1992, Israeli Supreme Court struck down only 22 laws, which is not a lot at all if you compare it to the American Supreme Court or the Canadian Supreme Court or the Court of Constitution in Germany, for instance. Now, it's very important to realize, especially for an American audience, that Israel lacks many common checks and balances that exist, for instance, in the US. So Israel don't have a rigid constitution. It doesn't have two legislative houses. It doesn't have presidential veto. It doesn't have federalist structure. It doesn't have regional elections. It doesn't have subordination to supranational courts. it doesn't have subordination to multi-level supranational organizations such as the EU. So basically, the almost only checks and balances on Israeli government is the Israeli Supreme Court and Israeli courts in general, because the government controls the parliament. How the government controls the parliament, this is very simple in Israel. Once the coalition is formed, it means that the coalition, that the government has at least 61 Knesset members who are in favor of the government and will usually do exactly what the government wants them to do. So the parliament in Israel is very weak. You have to realize it in order to understand the debate about the judicial and regime reform that Levin and Rothman, will talk about them soon, propose. So, okay, so this is the government, this is the Knesset, and as it is written down here, relatively strong and independent legal system, which is almost the only effective check on the government. I say almost, although I believe it's the only effective check on the government, but I want, to be balanced. So, okay, I'll skip that. Okay, so let's see the proposed reform. This reform was basically unveiled in January, just, a month ago, basically, by the minister Levin, and it is pushed by him and by another very influential Knesset member. His name is Simcha Rothman. He comes from extremist right-wing political party in Israel, and together they push this reform very, very fast. Too fast, much too fast. So I wanna just talk about two of the proposed amendments, so you'll get the picture. I'll start with the second point, which is prohibiting judicial review on basic laws. So basically, yeah.
Apparently the slides aren't changing on the screen so that everybody can see. You might want to check on that.
Okay,
You're only
so
seeing the first slide.
Do you see the slides?
I only see the first one myself.
That's strange. Okay,
Yeah,
so
you might need to go into the slideshow itself for it to see it, to show on the screen.
Yeah, there.
Now it changed.
Okay, so I won't do the view function. So basically I'll start from the second point, because I think this is the most radical change that Levin and Rothman urge and pushes very, very fast and relentlessly. So what does it mean, prohibiting judicial review of basic laws? It means basically that the Supreme Court in Israel will no longer be able to review basic laws. Now, why it's problematic? Because basically every law in Israel can be enacted as a basic law. You don't need any special procedure to enact a basic law. So if they want, for instance, I don't know, to enact a law saying that women don't have the right to vote, or that Israeli Arab citizens of Israel don't have the right for higher education. That's what bothers me as a law professor who teaches in almost all the faculties that I teach. 50% of Israeli Arab citizens. So they can act whatever law they want, present it, mask it as a basic law, and then no one can do anything about it, because their proposal is that the High Court of Justice will no longer have the ability or the authority to do judicial review on basic laws. This is what I see as the most dangerous proposal. We'll get to the second one. The second one is about politicizing judicial appointment. What does it mean? So in Israel right now, before the changes that Levin and Rothman want to push, right now, judges in Israel, in all courts, not only in the Supreme Court, are elected by a special committee. And in this special committee, we have representation of the government, representation of the opposition, representation of the Israeli bar, representation of the Israeli Supreme Court judges. Now, what they want to do now is to change the committee in a way that will give the coalition the majority in this committee. And this means that all the judges that will be appointed, not only to the Supreme Court of Israel, but to all courts in Israel, all of them will be elected by their political views, because they will feel obligated to the politicians that basically nominated them. And this is a very dangerous move in Israel, because as I said, we don't have in Israel the checks and balances that the US does. We don't have federalism, we don't have two houses of parliaments, and the only check and balance that we have, the court, will also be, according to this change, will also be obliged to the government. It's very hard to expect judges to have an independent opinions after they were nominated by politicians. This is the second thing. The third thing, which is called the override clause, it is here as a fourth point. It basically requires a majority of only 61 Knesset members who vote for a law that basically immunizes this law from judicial review. Now, what's the difference between the override clause that Levin and Rothman suggest and the override clause that now exists in Israel basic laws? So now there is only one override clause which exists in the basic law of freedom of vocation, and it allows the Knesset to override, that means to violate the right to freedom of vocation, if it does it by law that was enacted in the Knesset by a majority of at least 61 Knesset members, which is very easy to achieve for a coalition, because if you want a coalition, you've got to have at least 61 Knesset members that support you. So now we have only an override clause in the basic law, freedom of vocation. What Levin and Rothman want is to have an override clause over all human rights in Israel as they are entrenched in the basic laws of Israel, over all of them. It will mean that the Knesset will be able to override or to violate the right to equality, the right to freedom of speech, the right to property, all the rights that we have. And that's a very, very dangerous, especially if we think about minorities in Israel. Well, the Arab Palestinian minority in Israel, who are citizens of Israel, and the Arab Palestinians minority who are under the occupied regime of Israel also. The next very, very vulnerable minority are women. Okay, you have to remember that all the, almost exclusively, many of the issues about marriage and divorce and custody of children, for instance, are governed by religious laws. Jewish religious laws for Jews, or Muslim religious laws for Muslims, and so forth. So it's very dangerous. The status of women in Israel is already very vulnerable. So if the Knesset will have the opportunity to override or to violate the right to equality, then the situation of women will even be worst. The same goes for the LGBT community. The same goes for Mizrahi Jews. Okay, I'm a Mizrahi Jew. My parents immigrated from Egypt. As I see it, most of the times when laws discriminating against Israeli Arab citizens, they end up also discriminating against Mizrahi Jews. I'll be happy to explain that point in the questions and answers. I will now give my brilliant friend Tamar the option to talk.
Thank you. Okay, so I want to give a little bit of a more realpolitik analysis, maybe of what's going on in the way I see it. As Meital said, Israel has a very fragile constitutional framework to begin with, due to the fact that basically any norm can be enacted as a basic law. That's, I think, the basic flaw, that any law, any regular law can be enacted as the basic flaw. It should be said that the Israeli court has never yet invalidated a basic law or declared a basic law to be void. However, it did state on several locations that it does have the authority to do so in an extreme case under one of two legal doctrine. One of them is called abusive use of basic law, and the other one is if this is a basic law that negates the definition, the very core of the definition of Israel as a Jewish and democratic state. And the reason I state this is because what we're really witnessing here is an ongoing escalating constitutional crisis, in the sense that these changes are on the agenda, are on the table, and I'm going to elaborate a little bit more about the two other changes that are proposed that my colleague did not talk about before. But also these changes are on the agenda, they're on the table. If they will be enacted, they will be enacted through a basic law, not through a regular law, but through a basic norm. They will probably be challenged in the Supreme Court. The Supreme Court will have to address the question of whether it can declare these reforms, these changes, whatever you want to call them, invalid due to the fact that they were enacted through a basic law, which is basically a constitutional norm in Israel. And this is a kind of an escalating, ongoing situation. And I agree with the analysis that the fact that initially these changes were proposed as one package, and now the government has retracted in the sense that they're putting it in different pieces. And the first proposal they put on the table is that enacting a basic law stating that the Supreme Court does not explicitly stating that the Supreme Court does not have the authority to invalidate a basic law or to declare a basic law invalid, because once this is passed, then the entire other plan can be put into place. These are the conditions needed for the other changes to be put into motion. Now, if we look at the proposed plan, this is basically a two-track plan. One track is limiting the courts. We've heard, I'm not going to talk again about limiting basically judicial review. There are three different ways, three different proposals on how to limit judicial review of legislation. The first is to demand either an absolute vote of all 15 judges on the court in order to invalidate the law. If in the rare case in which this will happen, it's very unlikely to happen. There's almost always a minority or at least one dissent. But in the rare case in which there will be 15 judges or 80% of the judges, depending on the proposals, that decide to invalidate a law, the Knesset will be able to override such a law using an override clause that allows it to reenact a law, reinstitute a law that was declared void by the court. Plus, there will be a basic law stating that the court cannot declare a basic law, invalidate a basic law, which basically allows the Knesset to shield anything it wants to do by calling it a basic law, by enacting it as a basic law rather than as a regular law. So there's weakening judicial review. This is one part of it. There is changing the composition of the Committee for the Election of Judges, which is a means of taking over the court. And then there are two other parts of the reforms that are proposed on the table. One of them is to weaken judicial review of the government, of the executive, through limiting the grounds on which a government decision can be declared illegal, in particular with respect to reasonableness. So currently under Israeli administrative law, the law can declare a government action to be illegal due to the fact that it is not unreasonable. Again, there are different variations, different proposals on the table, but the general idea is to limit and weaken the ability of the Supreme Court to perform judicial review of the government, of the executive, not just of the legislator, through limiting the grounds or the reasons under which it can declare a government act, to be unconstitutional. Now, the fourth part of the puzzle regards legal advisors within the government. When we talk about checks of government power in the Israeli parliamentary system, indeed, the court bears most of the weight because the government basically controls the Knesset. The government always has a majority in the Knesset, except for in very, very rare situation when we have a minority coalition. But normally, under the Israeli system, the government controls the Knesset, meaning that the government can achieve anything it wants to do through legislation. That most of the weight of the checks on government power is vested with the court. So when we ask, well, what actually counters government power, including the government acting through the legislator, the answer will be the Supreme Court bears most of the weight of providing checks on government power. However, there are additional mechanisms within the government, additional institutions within the government. And one of these institutions is the institutions of legal advisors in the government itself, in government office. According to Israeli case law, legal advisors in the governments are public employees, which means they can't be replaced when the government is replaced. They're employees of the state employees. And their legal interpretation of the law, legal position regarding what the law says, is binding upon government actors unless the court says otherwise. So here again, there are nuances. I'm not going to get into them, but the idea is that if the legal advisor of a certain administrative unit or a certain department within the government states that something can't be done because it is illegal or not compatible with the law, then this opinion is considered as binding the government, which as binding the relevant organ, which is required, unless it goes to court, which is required to act in accordance with the opinion of the legal advisory. Now, I think what is crucial to understand about the legal changes that are proposed right now is that it is a mistake to analyze each of these changes separately and to look at each of these changes separately. Because especially, in the US case, we can say, well, the US has, political nomination of judges. It's not like democracy can't have that. Or, well, in a lot of democracies, legal advisors are, political appointments. And if the minister changes, well, why shouldn't he be able to change the legal advisor of the ministry? It is something that we see in state. It's not, inconceivable in itself in a democracy to think about these mechanisms. And I think in this respect, it's important to understand this proposed reform as a package. This is a package with one purpose, with one goal, which is to remove checks on government power and allow the government to achieve things or to do things or to pass legislation that it cannot pass under the current constitutional framework. So it's not just about every change in itself. It's about how all these changes operate together, and also whether are we adding any checks on government power, or are we only removing checks from government power? And when we look at all of the proposed changes together, then it's very clear that all of these proposed changes are meant at removing obstacles that the government may encounter when it wants to do things or to achieve things that it cannot do today. There's not a single change that is proposed that adds a check on balance on government power, or that adds an alternative balance. So if this arrangement or this mechanism is not ideal, fine, we'll change it, but we'll add something else that provides check on government power. All of these changes are geared in the same direction, removing any limitations, removing any checks, and it's a two-tracked plan or two-track package, in the sense that on one end, all of these measures are aimed at weakening balancing institutions, courts, legal advisors, etc. And on the other end, it's about taking over them. Right? So the government wants to take over the legal institutions, nominate the judges, appoint the legal advisors. But until that is achieved, until everyone is appointed by the government, in the interim period, the plan is to weaken these institutions. So we will say, well, the court doesn't have the authority to do this. And the opinion of legal advisors is not binding. It's only a recommendation. And the minister doesn't have to act in accordance with the opinion of the legal advisors. This is the package that has to be viewed as a whole. And the impact here has to be viewed as a whole. I'm going to say three more short things, and then I'm going to stop for the Q&A. And I think the question that we need to ask is, why does the government want this reform, and why does it want it now? Because we can have, an abstract discussion behind, a veil of ignorance about what should be the appropriate institutions in a parliamentary democracy when we talk about checks and balances, but we're not operating behind the veil of ignorance. All of these changes, they're not an end in themselves. They're a means to an end. They're meant to allow, some leeway to do certain things. So when we want to know, well, what is going to be done once these changes are put into place? And according to the coalition agreement, this precedes everything else. So all other legislation is stopped and halted until the legal reform passes. This is in the agreement. We need to open the coalition agreements, and we need to listen to, members of the Knesset, and we need to see the bills that are proposed, that are on the table now, that are brought by members of the Knesset, in order to understand what this, new legal framework will allow to do. What the end is. If this is the means to what end. And I think here the things that we're witnessing are very concerning. I mean, Dr. Pinto talked about a few things that worries her. I can tell you that from my perspective, if you ask me, well, what are you most worried about? I would say, I'm very worried about the political participation of Arab parties in the next elections. I think it's very clear that the agenda is to severely limit the ability of Arab political parties to take part in the elections. I think that freedom of expression is a very big deal. There are already bills on the table, proposed bills saying that, for example, presentation of a Palestinian flag will be forbidden in universities, et cetera, et cetera. So I think that's a very serious risk for freedom of expression. I think that rights of Palestinians in the West Bank are very much at risk with respect to this legal framework. For example, the Land Regularization Acts, which allowed building of settlements on private Palestinians' land, was invalidated by the court as unconstitutional. this legal framework will allow the government through the Knesset to reenact, for example, the Land Regularization Act. So this is one issue that's stake. And of course, gender equality, which was mentioned here before. And we also see in the coalition agreements these things. Now, none of these, and then of course, the main thing that we see just from this week is limiting the operation of the civil society organization and particularly NGOs. So just this week, there was a bill that was discussed or brought saying that NGOs that receive funds from foreign states, mostly in the EU, but also the US, will be taxed in 65%, which effectively means they will not be able to operate in the country. And these are all the next stage, right? If these are the means, and we're saying, well, what is going to be done with this legal framework? Then we can open the coalition agreements and we can open, the bills, and we can see. We don't need to speculate. We're not really behind the veil of ignorance when we don't know how this will operate in the future. I'm going to stop here.
I was on mute. Thank you both. That's a lot of information packed in, and I have a number of questions. Let me start though with one request that I got from the audience, and that was directed to Pinto. If you could send, if you have a copy of your slides, if you could send that to us, we can make that.
No, I don't want to do that.
Oh,
It's
okay.
just I prefer not doing so.
Okay, that's fine. So I have a number of questions. A couple of them really deal with how the proposed law would operate in some hypothetical circumstances. So let me give you one that came to my mind. Let's say that Netanyahu is currently under indictment and facing criminal charges for misconduct in office. Let's say that he's convicted by a trial court, and then the law passes, including the reforms as you described them. And then a new Congress, a new Knesset comes in with a majority of never Netanyahu members, and then the Supreme Court, the current Supreme Court, votes that the conviction was unlawful it violated a basic law. So then the new Knesset, the anti-Netanyahu Knesset, applies the basic law and overturns the decision so they can keep him in jail. Would that be allowed under this new law?
I didn't get the part in which a new Knesset is elected.
So, I mean, let's say there's a...
You have to have in Israel a national election,
Right.
in order for a new Knesset to be elected. So
I
even,
understand that.
for instance, even if Benjamin Netanyahu will be convicted,
Yeah.
he will be removed, but the Knesset will stay the same Knesset.
No,
The
but the Knesset has an end term at some point, either there's...
4 years.
Yeah, so let's say that he
Mhm.
takes a while. He's been under indictment for a long time. Let's say that this conviction is overturned by the Supreme Court. Could a differently composed Knesset then overturn that decision, the decision that overturned the conviction?
Well, yeah, basically, yes.
So here's another question I had. If you have some precedent, a Supreme Court precedent interpreting a basic law, and then there's a new case which raises the same issue that was decided before the new legislation was enacted, and the Supreme Court applying the new law finds that conduct that was previously protected is no longer protected. Would it eradicate the old precedent as well?
Well, not completely, but yeah, it will have a very negative impact on the old precedent, because once you have a new law, then the Israeli doctrine usually says that you have to regard it as, the new situation. Of course, there is also a doctrine saying that new laws should be interpreted as to respect Israeli basic laws, and should be interpreted as part of other laws in Israel but it is a very dangerous situation, that's for sure.
So one of the questions the audience has asked is about whether there are other types of reforms being proposed. I know that the president of Israel has suggested some alternatives. In the U.S. system, for example, we have some pretty strict standing requirements before someone can bring a case. I remember there was a case in the Israeli Supreme Court some years ago. It was brought by law students who challenged the concept of private prisons in Israel, and the Supreme Court struck that down as contrary to basic law. There are other elements, like maybe making it harder to enact a basic law than it is currently. So
yeah, I think that most constitutional professors, constitutional scholars agree that the changes need to be made. In particular, the pathology of the ease in which basic laws can be enacted is something that should be fixed. I don't think anyone thinks that this is an ideal situation. So if we would put forward a reform saying, it's a full package. We want to maybe and introduce some limitation on judicial review, but we also ensure that basic laws cannot be abused, and we also ensure that there is some sort of constitutional protection of basic rights. And there's some limitation, that there's limitation on the power of the majority to infringe upon rights, then reforms can be made. I don't think there's anyone who says, no, these mechanisms, these situations, they're ideal, or no changes can be made. This is not as an opinion. No one objects to opinions per se, or says that this is an ideal situation. The flaws in the system are very much clear to anyone who, I want to say anyone who practices or teaches, but now it's basically anyone in the country, because everyone became comparative constitutional lawyers. So I think the flaws in the system are very clear, okay, to everyone, and everyone understands that there's abnormalities here that need to be changed. But I think essentially the question is, do they need to be changed in a way that the majority can do whatever it wants or not? At the end, if you ask me, I think it goes down to this question. Yesterday, there was a Facebook Q&A with Metial Smotrich, and one of the people asking the question asked him how was it said? She said, who guarantees that you won't violate upon rights? And the question that he said, his answer was, I guarantee. He said, I guarantee. I, the Minister of Finance of Israel, guarantee here that I won't violate human rights. That's not good enough. First, because that's not how rights work. They don't depend on the government promising that they won't hurt them, violate them. And also because even if you won't violate them, then maybe a different minister will, or the next one will, the next one. That's a misunderstanding of the notion of rights, saying, trust me, I won't violate rights.
And also keep in mind that this specific Smotrich, this specific minister, a few years ago said that his wife should not give birth beside an Arab woman. He refused to let his wife enter the same room with Arab women. So excuse me if I don't trust him, because I don't. But in any case, as Dr. Hostovsky Brandes stressed this point, human rights do not work like that. They put limits on the government. They are not dependent on the government that will, want to protect them, or, promise to protect them. That's not the way human rights work.
So I have a number of other questions. One of them has to do with this petition that's been being heard by the Supreme Court. The current Attorney General, Baharav Miara, has asked Netanyahu to recuse himself while the Supreme Court considers a petition to remove him from office as unfit to serve. Now, she was appointed by Netanyahu's predecessor, but the former AG Mandelblit was, if I remember correctly, he was a Netanyahu appointee. Now he's been very critical of the legislation. I mean, and really blunt. He said that if the proposed legislation becomes law, there'll be no independent judiciary and Israel will have a different system of government. What weight do you think his opinion will carry with Knesset members?
What weight again? What
Will
was the
his
question?
opinion carry with Knesset members who are considering the legislation?
Unfortunately, not a lot, because as I see it, if we are, in the realpolitik mood, all Knesset members in the Likud party and in the other ultra-Orthodox religious parties and the right extremist party, they all follow Benjamin Netanyahu. None of them is, willing to say anything critical about Netanyahu or about this proposed reform, which is not a reform. It's basically a revolution. It's a regime revolution more than a judicial reform. I think that if Levin and Rothman really wanted like an authentic reform, they would change issues that really need change. Like, for instance, they can offer that Supreme Court judges will be elected in accordance with affirmative action laws in Israel. So Arabs will have more representation in the Supreme Court. So women will have more representation in the Supreme Court. So Mizrahi Jews will have more representation in the Supreme Court. But they didn't offer that because it is really not the issue that bothers them. They just want the power for the government to do whatever it wants to do.
So I have two related questions. One has to do with one of the supporters of the legislation who's written that the legislation typically goes through 3 readings, and there will be 2 more readings. If I understand, there's already been 1 reading. And one of the reform supporters, Michal Kotler-Wunsch, has argued that no legislation is passed in the same form after 3 readings as it started originally. Do you expect significant changes to come out of the process this time?
Tamar,
Well, first, there hasn't been a reading in the parliament yet. There's been a reading in the committee.
A prior reading, yeah.
A prior reading in the committee. There are basically 2.5 tracks through which legislation can go in Israel. There can be a private, the details aren't so important, but it hasn't gone through a formal reading. I think it's a very crucial question to understand. Actually, it's a very crucial question because it has to do with the question of when to be worried, right? What's the time frame in terms of time? And here's the answer. The answer is that between the first reading and the second and the third reading, changes can be made. The second and the third readings are usually together. Between the first reading and the second or the third reading, changes can be made. However, changes can be made with respect to the existing proposals, but you can't add in completely new subjects. Now, for example, some of our criticisms are not about what's in the proposal already, but about what's lacking. So we're saying, well, if you want to limit for example, limit the ability of the court to perform judicial review of legislation, then at least we need to entrench certain rights as basic laws. And these types of changes that are about adding things in to the existing bill are not likely to change through the different phases of legislation. So yes, changes can be made, but to a large extent, the first reading determines the scope of what can be done. You can't introduce serious subjects or issues that are missing completely between the first and then the second and the third reading. The second and the third reading are usually together.
I have another couple of interrelated questions, and this has to do with the agreement that Netanyahu entered into, I think in 2020, that limited his right to argue for the legislation. So
To be involved in the
yeah,
legislation.
I'm sorry,
Yeah.
being involved in the
Mhm.
legislation. So I know he's already been on TV and U.S. audiences to argue that this legislation is designed to bring Israel's judicial system more in line with other Western democracies. And we can argue whether that's correct or not. But has anybody argued that his making these public statements about the legislation to U.S. audiences is a violation of his 2020 conflict of interest agreement, barring him from having any role in the legislation?
Well, this is a matter of political analysis. It's not our expertise as lawyers.
Yeah.
I can tell you what my opinion is, but it's as good as any other political analysis. It's not a constitutional. I don't think, maybe Dr. Pinto has a different opinion. Contrary to what some people think, I don't think that Netanyahu drives this legislation at all. He's not the ideologist behind this legislation. I don't think it's about his trial, actually. I think there are other members. And this is the ideologist behind this is Minister of Justice Levin, he's really an ideologist in the way he perceives his majoritarianism and what the majority should be able to do in a democracy. It is Simcha Rotman from the Religious Zionist Party, who is a heavy ideologist on this. And I think that basically Netanyahu found himself in a position in which he is forced to put forward these changes by his coalition parties and by members from within his party. So I know that some people are saying, "Oh, this is all." There are people. That's why I'm careful, because this is, we don't know. But I know there is the opinion that says, "Well, this is about Netanyahu trial." Personally, I don't think that this is about the Netanyahu trial at all. Now that goes back to your question, because the answer would be, well, from a strategic perspective, maybe for those who hope that this will not lead to an explosion, but there will be some kind of compromise, then it's actually not that good that Netanyahu is prevented from, being involved with this, because it's a weird way to say it, but in a way, the hope is that at some point, Netanyahu will concede. And that's, I think, Pinto, what do you say?
By the way, the saying goes, I agree completely with what Tamar said. Well, Tamar doesn't know Benjamin Netanyahu. I don't know him. We didn't meet him personally. But I think Tamar's analysis is very accurate. And the same goes, by the way, to Aryeh Deri, as far as I'm concerned, because I was hoping that Aryeh Deri, as a logical person, would be able to reach some kind of compromise and to say to Levin and Rotman, just forget about this whole reform and let's do what we were elected to do, which is to govern, not to destroy the all the legal system in Israel. But unfortunately, Aryeh Deri was also, the Supreme Court in Israel also decided that Aryeh Deri cannot be minister in Benjamin Netanyahu government right now, because he was convicted too of several criminal offenses, and he promised the court that he will not be a politician again, in the sense that he will not put himself to be elected as a Knesset member or a minister, and he just violated his promise. So keep in mind that we have a very, very, I think, a very, very hard problem of people in the government, Knesset members and ministers, who are very corrupted. It become very, common that ministers receive bribery, that they violate all kind of criminal laws. That's the atmosphere in Israel. It becomes very regular. Oh, okay, this minister was convicted. This minister was.
So last couple of questions. I know we're getting near the end here. In terms of support for the proposals? I know you talked about a lot of the arguments against the proposals. Are there academics that are behind the proposed legislation?
Of course there are. There is a very dominant, we'll call it a think tank in Israel, which is called Kohelet. Most of the money comes from the US. Some of it comes from non-Jews as well. Some say it comes from evangelist politicians. And they employ actually legal scholars who draft proposals, and then these proposals are going to the Knesset. It was this way when it comes to the basic law, the Jewish Israel as the home of the Jewish people. It was basically drafted by legal scholars in Kohelet, and then it was enacted by the Knesset. The same goes for Levin and Rothman proposed changes. All of them were thought about, and all of them were drafted in Kohelet think tank, and then they went to the committee that wants these changes to be enacted in the Knesset.
But I think it's fair to say that the vast majority of Israeli academic and of Israeli constitutional scholars oppose the package as it is. And when I say vast majority, it really is vast majority. And I don't remember an issue on which we were, academics, we're each
so united.
We're each a unique snowflake with our own flavor, but I don't remember an issue on which there was, such broad consensus among constitutional scholars with respect to that, how severe the situation is. We set up a Law Professors Forum for Democracy. We've been holding house talks and explaining, we've been doing outreach to the public. Metial and I, we've been speaking at workplaces, private homes, I don't know what else, community centers. Soon we're going to start doing bar mitzvahs,
schools, bar mitzvahs and weddings.
We're basically speaking to whoever is willing to listen about the reform, and we have a group of a few dozen academics that are doing this voluntarily. Going house to house, place to place, wherever there's 20 people gathering together. We'll go all over the country, because we really feel that this is a crucial time. It's not our usual mode of operation. We're not activists, we're academics. But we felt that this is a time in which we cannot stay in the, ivory tower and talk to students as if nothing is going on. And I think the vast majority of constitutional law professors and law professors in general in Israel perceive the reform as, something that is as a very, very dangerous package. Of course, among us, some say, well, this change should be made or that change to be made. And you have varied opinions about what the ideal constitutional framework or the ideal institution will do. Law professors, dozen opinions, but there's agreement that what's on the table now is something that we strongly oppose.
So that leads me into the last question. A Times of Israel article cited a recent poll that more than 60% of the Israeli public wants the government to halt or at least delay the legislation. So my question is, does that seem accurate to you? And if so, do you think public sentiment, including the discussions you've been having, you and other professors have been having with the general
Very
public?
accurate. I'll tell you more. When I come to, houses and deliver the lectures about Levin and Rothman suggestions, I meet people who actually voted for the Likud party, who voted for Levin, and they're saying to me, well, Pinto, believe me, I didn't mean for my party to do this. I didn't mean for my party to destroy the legal system in Israel. So it's not only, the center and the left, it's also people who realize that what's behind this reform is basically to give the government exclusive power on everything. And
we
they
also see
realize that.
And we also see sectors that are usually not politically involved in Israel. So we see the high-tech sector, then we see the economist, in the Israeli civil society, these sectors are usually not politically involved. They're very mainstream because their notion is that this is not about political dispute. This is about an illegitimate move, something that is beyond political dispute. So we see, high-tech companies giving their employees a day off for the strike on Monday. I think because by many Israelis, this is perceived as something that is not normal. It's normal to have very heated political dispute, but this is something else.
Well, I know there are lots of more questions, and I really apologize to people who posted them and didn't get to have their questions asked. I know we've covered a lot of ground, and I hope we've covered some of your questions, at least indirectly. But I want to give my special thanks both to you, Pinto, and to Tamar for your thoughts and insights, and believe everyone on this call and all of us who care about Israel and its democracy are going to continue to follow this closely. So again, thank you to both of you. I do want to conclude that this actually concludes our webinar series on understanding the impact of Israel's new government at home and abroad. We're going to make a recording of this available after today's webinar, and both of this webinar and the prior ones in the series. And just also a reminder for those of you who are signing in today as part of our virtual brown bag lunch series, that we're going to have another one on March 15th. And this one will be on the intersection of domestic abuse and gun violence. Details are on the JCRC website, and we'll also be sending out notice about that and about the speakers. So again, to both of you.
Harvey, can I say just something,
Yeah.
a little something? So I am addicted to Facebook. I have a Facebook account, which is completely public. I'm saying it to the audience. If you want to ask me questions, just, befriend me, just send, you don't actually need to be my friend in order to contact me via Facebook. So I know it's a very old, it's a very old mechanism to communicate, but still it exists. So do it if you want to.
Thanks. And I take it that would be pretty easy to look you up if people want to do that. So again, thank you both. And
thank you,
Very
Harvey.
much for the invitation.
And thanks to all of you for signing in today.